fender bender, those statements can drastically reduce the value of your claim. And if they show up in the records, as a lawyer, it's almost impossible for me to overcome those statements, not without sufficient work or not without much more treatment and expert opinions from other doctors to refute those statements. But even if I have that information, because they show up in the records, if the case were to ever go to trial, typically the defense attorney will blow up those records into a big poster so that the jury can see how you were describing the accident in such an insignificant way. And that can be very, very powerful evidence to a jury to award minimal compensation or award no compensation because they don't believe the accident was that bad or they don't believe your injuries were that severe. Mistake number 9 that we see is when the client really makes medical appointments but either fails to make those appointments or goes long periods of time without seeing a doctor, which we refer to gaps in treatment. If you are having symptoms from your accident, you should be regularly seeing the doctor. We get cases where somebody might treat for a few months and then stop treating for 6 months or longer, or even just a few months, and then pick back up again and resume treatment. When we have those gaps in care, again, the adjuster is going to latch onto that and wonder, well, he stopped treating and then didn't pick up again until 6 months later. How do we know he wasn't injured again? Or why would he stop treating unless he was feeling 100% better? So those types of things that we see can also be very big challenges in a case and be difficult to overcome when trying to settle the case for a reasonable value. Finally, number 10,